Good morning, one and all, and welcome to 2021. You will be forgiven for thinking that 2021 is the year 2020, as we started off with an adjusted lockdown level 3 with curfews, no alcohol, but for smokers, well, we can't smoke now. The question as we await the vaccine, which is due to arrive on the 1st of February, is simply what are an employer's obligations towards its employees having regard to the various regulatory regimes. In 2020, the book The Plague by Albert Camus, who wrote in 1945, sold out. The publishers indicated that they were having difficulty keeping up with the demand for the book. And you may ask, why was the book of such relevance? Because it spoke to our human nature, a human need, and how do we operate amongst each other and towards each other during a pandemic. People reading the book thought that the book was written in the year 2020. It seems not much has changed from 1945 to date, save for the fact that we now have on our shores the potential of a remedy or a cure, which is order to delay the severity of COVID-19. My name is Adil Patel, and I'm at the Employment Department of Cliff Decker Hofmeyr. With us today, we have Safura Abdul Karim, Professor Hugo Pina from our department, and Imran Mohammed, who are going to talk to you about this issue. What we're not going to talk to you about, colleagues, is the science regarding the vaccine. You would have seen yesterday or the day before that the regulatory authorities have also, for compassionate, allowed ivermectin to be dispensed with for compassionate reasons. There has been various studies done regarding the vaccine. What we want to assist employers with is to navigate how do we maintain a safe working environment for our employees during the pandemic. You will receive from our marketing department a thought piece regarding the issues that will be discussed today. Our first speaker is Safura Karim, who has a number of credentials to her name, but for the most important ones are she's a PhD law candidate at the University of KZN, and her topic is developing and applying a constitutional right-based approach to the regulation of modifiable risk factors for non-communicable diseases in South Africa. She's got an LLM from Georgetown University Law Center, where she passed with distinction, and her topic was a focus on public health law, regulation of health systems, and right-based approaches. Some of her publications, which she has written with other colleagues, are industry strategies in the parliamentary process of adopting a sugar-sweetened beverage tax in South Africa. And then she's written in the Lancet Journal in 2020, COVID-19 vaccine affordability and accessibility. But I think her most important credential is, like us, she's a lawyer. I give you Safura, who's going to set the scene from a legal perspective before she hands over to Professor Hugo Pinar and then Imran Mohammed. What we have, you would see that this is different to our previous webinars. This is for 1.5 hours. Hopefully we're going to leave 45 minutes simply for questions. I'll moderate the questions after our speakers have spoken. They'll be speaking for 15 to 20 minutes to give you a taste of what is to come in the months ahead. Thank you. We have, as at the last count, 1,200 acceptance and participants on this webinar. Thank you.
Thank you so much for having me this morning. It's really a privilege to join some fantastic legal minds to address what I think is a particularly timeous and important conversation. You know, the landscape around vaccines, and particularly vaccines in South Africa, is changing day by day. And I think this could not come at a better time, given that the minister yesterday announced that our first vaccines will be arriving on our shores on Monday. I think, you know, as Adil outlined, this is not about the science of vaccines, but rather what I'm seeking to do is provide context around vaccine rollout, why an employer might want to consider a vaccine, a compelling vaccination or vaccine policy for their employees, and what that role would be in the context of the COVID-19 pandemic. Now, I think we all have come to understand that vaccines are integral to ending this pandemic, not in South Africa, but globally. But what that will take is complicated. There are a whole lot of other issues Adil has mentioned that I've looked at around accessing vaccines equitably. And we know that many countries in sub-Saharan Africa and poorer countries around the world are going to experience immense delays in vaccinating their populations. So this is a conversation that is happening early, and I think it's very important because it's not a premature conversation. At some point, we will have to consider how we achieve herd immunity in our population and how we begin to roll out mass vaccination. That is an effort that has not happened in South Africa previously. We have strong vaccination programs for children. We do have a seasonal influenza vaccine program, but there's never been an attempt to, at large scale, vaccinate a significant portion of the population, particularly adults. Now, the government has put in place all sorts of measures. Some of them were outlined yesterday. And I think it's important to understand that even with all the government's measures, employers are going to be a particularly important block in the chain of ensuring that people get vaccinated, particularly where multiple vaccinations are required. Now, the idea of immunization and why it's important to our population, I think, is something that is reflective of an underlying principle in our COVID response. There are particular populations that suffer from severe COVID and suffer the extreme adverse effects, including mortality from the disease. But there's a large number of people who don't, who have mild COVID, who catch it and get over it very quickly. But our underlying approach through lockdown, through the adjusted risk strategies, has not been about protecting individuals, but about protecting our society at large. Each measure that we take is not about necessarily improving our own health, but about preserving the public health of our communities, about preserving and protecting our healthcare system. And that underlying principle, which in a way is reflective of the South African principle of Ubuntu, should also underpin any vaccination strategies. You getting a vaccine is not per se about individually protecting yourself, but it's about protecting your community or your workplace. Now, COVID-19 is not the first pandemic that we faced, particularly in South Africa. We've had an HIV epidemic, we've had severe TB epidemics, and so as a result, there's a lot of legal infrastructure in place around regulating, treating, and preventing these kinds of diseases. When COVID-19 was discovered and when it began to spread in South Africa, it was very quickly made a notifiable condition under the National Health Act. And so in many ways, the treatment and prevention of COVID is regulated under the National Health Act as well as the Disaster Management Act. Now, there are provisions in both of those acts that allow the government to compel somebody to take a vaccine if that was necessary. But that's quite an onerous process. It happens at an individual level where somebody is refusing the treatment or, for example, vaccine, and then somebody would need to either approach a magistrate or a judge in the High Court, depending on which regime was in force. And so I think that's not really going to be feasible for mass vaccination. So again, this sort of highlights the need for employers to think about what their role is within broader prevention of COVID-19. The other thing is that, the other thing I wanted to mention in terms of vaccination is that we have only one type of measure where there's sort of an incentive to get vaccinated, and that's for yellow fever. And basically it's a requirement when traveling to certain countries that you have a kind of immunity passport. And so people have been talking about whether or not something like that should apply for COVID. And the reason I mention it is because there are many ways in which to create an environment where people have to take a vaccine beyond using things like the National Health Act or the Disaster Management Act to force people to be vaccinated. So something like an immunity passport is very likely to be implemented, not just in South Africa, but globally. And so there will be kind of other systems in place. For example, kids may not be able to go to school without being vaccinated, etc. And so they are the idea of what it is to incentivize people to be vaccinated is complicated. It's not straightforward, but there is precedent for it. And so I think as lawyers, we need to draw on what are the existing measures that have been used and how can we adapt those to support vaccine rollout in South Africa. The thing that I think is unique with COVID and is worth mentioning is that this vaccine was developed at an unprecedented speed, and I think there are many things that arise with COVID where we use the terminology of unprecedented. But really, the vaccine, to come up with a vaccine a year after the virus was discovered is unprecedented. The development of that vaccine has also led to a lot of unusual situations. For example, regulatory authorities have granted emergency use authorizations for vaccines, which is a lower threshold than would normally apply. There have also been several efforts to limit the liability of pharmaceutical developers, and the reality is we don't know what the long-term effects of any of the vaccines are. Similarly, this expedited process has built on an already kind of sinister anti-vaccination sentiment that grows globally, and a global mistrust of science and a global mistrust of things like vaccines. So it's important that we contextualize our vaccine rollout strategy, not just in the context of people who want to take a vaccine, but understanding the reasons why somebody may not want to take a vaccine and accommodating those types of things. This is not a situation of one size fits all. We need to think about multiple strategies that will create an environment where people want to take a vaccine. And that is where I think there's a role to be played for employers to be educating people. In public health, compelling, forcing, criminalizing, these are the sort of the bottom of the rung in terms of the way we would want to implement interventions. Our first prize is always for the public to buy in and to want to contribute to disease prevention. And so I think it's critical that we understand that forcing people to be vaccinated is not really the first prize. We would want employers to play a role in educating their employees and things like that. So I think the fundamental point, and I think it will be very interesting to hear what the employment lawyers at COFDECA have come up with as they've thought about these issues, is that there isn't a one-size-fits-all solution to this. The landscape is complicated, and there is a need to understand many different viewpoints and accommodate many different types of people. There are people who can't have a vaccine for medical reasons. For example, there are people who will object on religious grounds, and there are people who will object on philosophical views. And there needs to be a give and take. Each group of people in each community, whether it's an employment community or broader community, need to think about what makes sense for their particular context. How can they take steps to make sure that they can do their part in preventing the pandemic. So I'll leave it there and hand over to Prof. Pina, but I'm happy to take any questions.
Thank you. I'm ready to go. Good morning, and again, thank you for attending. Of course, as we've indicated, this is really a complex issue, but of course, it's not new. There's already a case decided on this point in the year 1905 in the United States. Now, of course, when I refer to the United States, I must immediately say that this isn't fake news, but there was a decision in a case of Jacobs versus the state of Massachusetts. I've also checked, it's definitely Jacobs and it's not Jacob, for those that may be confused about that particular topic. So already in 1905, the Supreme Court in the United States dealt with a case of smallpox and the issue of compulsory vaccination. So let's then take you through the topics and how I intend to address this today. Now, as I've said and has been highlighted, this is an extremely complex issue where you sit with competing or opposing rights. You have the rights of the individual, and then you have the rights of the collective, and there's this whole herd immunity concept that goes with it. So what we intend to do from our side is I will give you sort of a framework of the relevant legislation that may or may not be applicable, and that should be considered by the employer if they want to introduce a program where they force employees to have the vaccination. So I'm going to look at the constitutional principles, and it's incidentally there are 9 constitutional principles that may come into play. Several principles from the Labour Relations Act and the like. So I'm going to deal with first general considerations by the employer if they want to introduce a compulsory vaccination policy. So the first, and I'm just going to highlight, not going to go into detail, but highlight some of it. So the first one is obviously the one that there's a duty on the employer to provide employees with a safe working environment, and that may ultimately culminate in a policy. And if an employee refuses to comply, the question would be, and this will constantly be the question that we need to answer, will the employer be entitled to terminate, and is such termination then based on misconduct, incapacity or operational requirements? And Imran will delight you with his insight on that. So the first point of departure is the employer's duty to provide employees with a safe working environment. The second one is, of course, comes from item 4.4 of Schedule 8, which says that the employee has a duty not to endanger the life of a fellow employee. And again, comes into play the collective as opposed to the individual rights that we've alluded to earlier. The third one is an interesting one, because we know that there's generally a duty on an employer to mitigate against job losses. And now I'm referring to Section 189 of the Labour Relations Act. So we've often seen companies closing because of constant infection of the workforce, laydowns and shutdowns, and eventually there are job losses. So the employer can, in fairness, argue, I need to put processes in place in order to mitigate job losses, and that's certainly a fair consideration. What other rights may employers have? Well, they may consider utilizing the lockout provision. In other words, unless you get a buy-in, and assuming that you need a buy-in, because there's an argument to say that you can unilaterally implement. We will debate that later if we have time. But I mean, let's assume the employer decides he's not going to get the voluntary participation. Of course, he can consider locking out its employees until they accept the compulsory vaccine. That's a very harsh decision, and but it is an avenue available to the employer. I'm not debating the good or the bad of that, simply to say that it is there. Then There may be two categories of employees. One category may come to the employer and say, well, we want you to implement this, and another category may say, we don't want to, and we now want to engage with you and negotiate with you our right to have a vaccine policy imposed in the company. And the employer can simply say, well, I refuse to negotiate. Or on the other hand, the employer say, I want to negotiate this with you, and if it's necessary, of course, as I've said. And then the employees or the union can say, I refuse to negotiate with you, and then comes into play the provisions of section 64(2) of the Act. So all the time you have interplay between the Labour Relations Act and, in that context, the individual as opposed to the collective rights. The most important point I think employers may consider utilising is, of course, section 7 of the Employment Equity Act, which allows for medical testing, and it's not subject to section 52 of the Act, which is the case with HIV tests, where you need to approach a labour court. But you know, there are considerations which may come into play, and depending on those factors, it may justify policy to that effect, i.e. medical fact, employee conditions, social policies, inherent requirements of the job, and I'm going to come back to case law on that. But those are factors or justifications to be considered by the employer when the employer wants to impose compulsory vaccination. Of course, this also applies to applicants for positions. That does not mean that employees can't raise the issues and objections that I'm going to allude to a bit later. There is an interesting clause that the employer can also rely on, and that's section 23 of the Constitution, because section 23 of the Constitution says everyone has the right to fair labour practice. It doesn't say, as with the other provision, the employer has or the worker has. It says everyone has the right to fair labour practices. And what could this constitute a fair labour practice or a policy? How far do we draw that line or extend that limitation? And again, will come into play the group of employees who may want to have the policy as opposed to the other group. I've already alluded to the right of the lockout. So let's briefly look at the rights that the employer must consider of employees when wanting to impose a right or a compulsory vaccination. So, and I've said 9 constitutional points may come into play. The first one is section 9, the Equality Act, the equality provision. It says you may not discriminate on a number of grounds, such as religion, disability, conscience, belief, and culture. And I'm going to allude and refer you to some case law later, which will show you how the courts have in the past dealt with conscientious objectors. But certainly the first one is section 9, the second one is human dignity, section 10. And you would have seen that in the past where the courts have dealt with this principle, it says, what's the impact on the human dignity of the particular employee when you want to enforce a policy such as you may not have a beard and you must be clean shaven and the like. So that's the second one. The third one is the section 12 one, and that is security of person, the right to body integrity and the like. Of course, I thought interesting in that is there's also the right not to be tortured, and I thought maybe the employees in our employment department are excluded from that torture provision, but that is also there for those who want to rely on that. Then the fourth one is the freedom of religion and opinion, and it's here where I just want to refer you to some case law, because it's not as simple as it looks, and you simply say, I'm going to raise an objection, it's against my belief, it's against my religion, and just briefly touch on some cases where the courts have decided on that. The first one is the Green for Security case, where people from the Nazarene faith said that we're not going to shave our beards, and it's against our faith. And there was again a dispute and a dismissal about that. And the company said, well, it's a contractual right. I'm entitled to, and you've signed a contract of your employment. And when you commenced employment, you did not, you were all clean shaven, etc. And then the court in that particular case said there was a clear purpose of that provision in the Act. it's dealt with the inherent requirements of the job. But what the court did say, and I think that's a test that the employers must constantly consider, and it's with reference to other case law, is whether it would cause undue hardship on the employer when you have people wearing or having a beard in this particular case. But the undue hardship is a constant reference to court when they want to enforce these sorts of rules and there's no objection to a particular policy. Of course, in this case, the court said, and that is important, it analysed the Nazarene faith, and it said the shaving rule was not an essential tenet of that faith, and on that basis said that that it was an inherent requirement and dealt with it on that basis. So 2 points from that is that they will analyse the faith. What is the context? Is it an essential tenet of the faith or not? And of course, what is the substantial or cause of undue hardship on the employer? And I would suggest also considering the consequences and dignity of the employee. The next case, I'm just going to take you briefly through that. That's Seventh-day Adventist, and this is an employee that refused to work on a Saturday on stocktake, and there was overtime and all of that. And in this case, the court said, did it impair the dignity of the employee? And what is important for us in the considerations here is that the court said you must look at less restrictive means that may be available. And again, in this case, there was no hardship to the employer. But what was interesting is that the court said the onus is on the employer to make and to consider alternative proposals, etc. And those are the factors that the employer will have to consider. Pop crew case, just briefly, the dreadlocks, the employees relied on their faith and their belief, and that their dignity was impaired, and noted in that case females were also allowed to have dreadlocks, and there was no rule against that. The rainbow chicken one, that's the one where it dealt with the issue of employees not working on EAT, and the court did the undue hardship test, and again held against the company based on its inability to consider alternatives, albeit it be on short notice. I thought the last case, just briefly, and I'm trying to be as quick as possible, and this is the Kiewicz-Kroon case, because the relevance of the Kiewicz-Kroon case was about the Sangoma, the person undergoing training for this Sangoma to become a Sangoma, and the court said, I can only scrutinize the sincerity of the employee's belief. The court is not equipped to evaluate the acceptability or other consistency of belief. And then ultimately the court said the belief was reasonable. Now, of course, that brings into play almost a subjective factor, and how would you deal with it as an employer if the employer says, well, you know, my belief or conscience is reasonable, and you can't really question that, and then you get into the herd community argument about the collective and the individual. Just going to raise some other topics of the Constitution that will come into play. Political rights, not necessarily relevant in our country, but already we've seen in the US the anti-vax campaign, and that may lead to political rights being inferred. The labor relations provision under Section 23, everybody has a right to fair labor practices. I've alluded to that. Cultural communities, Section 31, Section 32, access to information, that will come into play in disputes with the state. But most importantly, when we deal with constitutional rights, we know that no right is absolute, and Section 36 is the limitation clause. Then, of course, employees may have reference to the Labour Relations Act, and let's just pick on a few clauses there, the sections that they may rely on. One is Section 5.1. You may not discriminate or prejudice an employee seeking employment for that employee exercising his or her right in terms of the act or otherwise. Section 23, Imran will deal with that. That is to utilize collective agreements with trade unions to impose such rights. I thought an interesting one is the principle of free riders, because it often comes into play when you look at international case law and articles. What about free riders? So I have a workforce of 100, 3 people say I'm not going to vaccinate, and for whatever reason, it may be personal, it may be based on any of the reasons that I've mentioned, it may be because of the personal medical circumstances, and they become what we would maybe refer to as a free rider. That concept is not new, because in the Labour Relations Act we have section 25 and 26 dealing with agency shop and close shop agreements, where there's specific provisions to address free riders. In other words, there would be consequences for free riders, albeit it be in a different way when you look at section 25 and 26. Of course, employees can declare a dispute of right, and employees can go out on strike about the employer's intended imposition of this right, so-called right to have a vaccination program. There's section 64, there's a unilateral change of conditions of employment. Employees may say, well, when you employed me, there was no such condition. This is a new condition, albeit it be in policy, and or maybe you may say that you have the prerogative to impose that unilaterally, but it still constitutes a unilateral change of conditions of employment, and hence you're infringing on that right, and that may ultimately also lead to a strike. Of course, when you look at the Labour Relations Act, immediately will come into play, if you have such a policy and you want to enforce it, employees do not participate, what are your rights in terms of the Act? May you terminate? And if you terminate, will that be based on misconduct, i.e. refusal to obey an instruction? Was it a reasonable instruction? 2, is it about the incapacity of the employee to perform, and then all those other matters will come into play when you deal with principles, when you deal with incapacity. Did you consider alternatives? What alternatives did you consider? Were those reasonable alternatives, etc.? And then the third ground, could it constitute a ground for dismissal based on operational requirements? And of course, Imran is going to talk about that, but immediately will come into play provisions of the Basic Conditions of Employment Act. If I make a reasonable alternative offer to the employee doesn't accept, the employee may forfeit severance pay if you decide to go this route. The next important point the employees may rely on, and we've seen that in the cases, is section 187 of the Labour Relations Act, which is the automatic unfair dismissal. That is, if I dismiss somebody because of his or her political beliefs. And the importance of this is this carries a 24 months compensation cap as opposed to the other provisions. So those are just some provisions in terms of the Labour Relations Act that employees may rely on, and that employers will have to consider when wanting to impose such a policy. Other principles that may come into play: Basic Conditions of Employment Act, there's the issue of employee rights under section 78, but also section 23, when you look at medical proof of incapacity. Employee may come and say, well, and this is not about absenteeism, but the employee may say, here's a medical certificate, it says that I cannot have a vaccine for the following reasons. And of course, the courts or you may consider the principles set out together with that set by the Medical Council for medical certificates. There's a POPI Act, Imran will talk about that. There's a National Health Act, which is about risk to public health. So what I am saying is that it is an extremely complex issue. There are various rights and various opposing rights. It's about the collective as opposed to the individual, which was already being referred to. But it's ultimately finding people to get their consent as opposed to unilaterally imposing whatever rights you may have or you think you may have as the employer, and then strike that balancing act. To conclude, we're going to move into a sphere of huge changes. We've referred to Ubuntu. Lovemore Mbuki, the writer of the book Ubuntu, said it's about change. And how do you deal with change? You manage it rationally, or you let it happen chaotically. Those are the choices you have as employers. Thank you. I'm now happy to hand over to Imran. He will delight you on some of these topics that I've addressed, including some new ones. Thank you.
Good morning. Thank you, Prof. With everything that has been said in relation to the topic, I'm particularly guarded in saying that this is a fascinating legal issue only because of the severity of the issue at hand. But the issues that you've raised and those raised by Safura endorse exactly what's been said earlier about the complexity of the issue that employers are going to have to face in an instance where there is not going to be a law of general application, which certainly does not seem to be the case, where government is going to impose a requirement for a vaccination of the entire population. So in this segment of the presentation, I want to start off on a discussion with regards to this question of consultation. Safura touched on it in her presentation and spoke about it in relation to particular communities and how it's to be dealt with, and we look at it from the perspective of a workplace. It can be accepted as a general principle that any vaccination policy by consent is going to be much better to be implemented than by compulsion. And it's also likely to be more effective in relation to its rollout. As a general proposition, I think we can all come to accept that. Now, consultation may well also be a legal requirement in the imposition of a mandatory policy by an employer under the Occupational Health and Safety Act. Professor Pinar discussed or touched on the issue of an employer's obligation to maintain a safe working environment, which essentially is the starting point for an employer in a determination around this complex subject. The concept of a safe working environment is a right is between employer and employee, is between employees and other employees, and in respect of an employer with regards to third parties. Now, in respect of this question of consultation, we know in the employment law sphere that consultation does not equate to agreement. Safura touched upon in her presentation on the aspects of the National Health Act. So medical treatment under our law requires express consent by by a person who's going to receive any form of medical treatment or medical care. There's an exception to that, and the exception is either a law of general application or a court order that authorizes the provision of the health service, or alternatively, where the failure to treat a particular individual or a group of people in this particular instance will result in a serious risk to public health. So that would result in an exception under the current legislation in the form of the National Health Act. Now, in the seriousness of the risk to public health easily fits and sits easily within the exceptions in the Act, but the concept of consultation is the better concept because it's going to allow for more effective rollouts within the workplace. That then begs the question as to when should consultation commence. Safura started out her presentation with reference to the announcement that was made by the minister yesterday, and she made a valid point that this discussion is not a premature discussion, and it's certainly one that a number of employers that we are aware of are already considering in relation to determining whether a mandatory policy should be applied in their particular workplace. So that's going to be the first step for an employer, is a determination as to whether or not a mandatory policy should apply to its workplace. So once an initial position is taken by an employer, then the process of consultation should commence, and it should then commence in earnest. Government's intention is that we should get to a 40 million mark in relation to herd immunity by the end of this year. That's the stated objective. There was discussions or points made last night that in the mining industry, with an existing infrastructure in relation to health services in that industry, the intention is or the projections are that there could be vaccinations of up to 80,000 people on a particular day. So the government's intention in relation to particular workplaces is that there be mass rollout so that we can get to a herd immunity very quickly. The logistics around all of that and how that's implemented with a population in excess of 54 million is going to be a mammoth task. But in respect of the context of a particular employer, that becomes somewhat academic because an employer's got to look at its own particular circumstances. So with regards to the concept or the question of consultation, the question is who takes the initial view in relation to the policy for an employer with regards to a particular vaccine in the workplace. Is that a concept to be consulted upon widely with all employees? Is it an issue to be consulted with particular categories of employees, or an issue to be dealt with particular trade unions? A question that's also then begged is what happens in an instance when agreement or is accepted by a majority trade union that there should be a mandatory policy within the workplace. Prof. Pinard referred earlier in his presentation to Section 23 of the LRA, and an interesting issue then arises that with regards to the acceptance now in our law of majoritarianism following the Constitutional Court judgment in Enku and Royal Bafokeng, where the Constitutional Court accepted that a majority trade union has the ability to extend a collective agreement to non-members. Would it be appropriate, would it be lawful in this particular context for an employer to conclude an agreement with a majority trade union, which is then extended to all employees in relation to a mass rollout of the vaccine? So consultation can give rise to agreement, and where there's a majority trade union, an employer may get to a point of making or having to grapple with that particular issue. So turning away from the concept or the discussion on consultation and the like, moving on to a different topic which relates to data protection. We will all know that the Protection of Personal Information Act comes into full force on the 1st of July 2020. So to add to the woes and complexity of the debates and discussions that are going to be had with regards to mandatory vaccine and constitutional issues, employment law issues, particularly out of the Labour Relations Act, the Employment Equity Act, constitutional rights and the like, is now the obligation of an employer to also ensure data protection under the Protection of Personal Information Act. What immediately stands out under the Data Protection Act is that the definition of personal information, what's categorized under the Act as special personal information, would certainly come into play when requesting employees or potential employees to make disclosures regarding their medical or vaccination history to an employer, and how that information is then to be collected, stored, and eventually disposed of by an employer has to be in full compliance with the POPI legislation, because an inability to do so then renders the employer liable to potential or non-compliance with that act. A further issue that then needs to be considered in relation to the data protection legislation is how to put in place measures in order to avoid a limit and a full risk of a data breach of information that's obtained from employees relating to medical conditions. I then want to turn across to another complicated area that Prof. Pinard touched upon, which relates to reasons for dismissal or termination of employment, as it were, for employees who refuse to be vaccinated. Now, I want to start off this particular subject with this general proposition that there can't be a general position that applies. It's going to be fact dependent, and it's going to apply to particular circumstances of particular employers and particular circumstances that apply to particular individuals. So, because of the provisions in the health legislation, if an employer were to exclude an employee who did not take a vaccine, the question then arises whether or not the exclusion of the employee from the workplace in that instance does not amount to compelling the employee to indirectly take the vaccine. Now, in order to do so, what ultimately then happens is that an employer is not requiring voluntary consent from an employee, but is indirectly putting pressure upon an employee in order to obtain consent. Now, if the consequence is simply that the employee will continue working remotely and be able to render services in a remote working environment, and no other prejudice will be suffered by the employee who refuses to give consent to the vaccine, well then arguably that employee should be safe from a termination at the hands of the employer. But what happens in an instance where an employee can't work remotely? Take a mine worker as one example, or a cashier in a supermarket as another. An employer's policy there, which then requires a compulsory vaccine in order to retain the job, the employee in that instance may not retain the ability to decide, well, I refuse to take a consent or not to give consent in that instance because of the operational circumstances around that instance. So what sort of claims can employees likely rely upon? Prof. Pinar touched on a unilateral change to conditions of service. That's one that immediately comes to mind. An employee would simply rely upon the current terms and conditions of employment to say there's no requirement in my contract to take a vaccine, and to impose it would constitute a unilateral change to conditions of service. Now we know under the provisions of Section 64 that two employees who take that sort of a position have the ability to go out and strike. So that sort of a dispute potentially has the ability to grant an employee the right to strike. A second form of claim that could potentially be relied upon by an employee is unfair discrimination, having regard to the consequences of a workplace policy, i.e. being a mandatory vaccine policy. Thirdly is the potential of a constructive dismissal claim, and we all know constructive dismissal claims are very dependent on facts, but it's not certainly without dream that constructive dismissal may end up being a form of termination for an employee, where an employer makes the imposition of the policy intolerable in a particular work environment. Then there's the potential of an automatically unfair dismissal. Prof. Pinar touched upon that, and every one of the constitutional rights, or at least a vast majority of the constitutional rights that Prof. Pinar highlighted with specific reference to the Constitution, in fact, find themselves in the LRA in Section 187. So an employee can found a claim of a dismissal that's automatically unfair, where the employee is able to show that the employer unfairly discriminated the employee on a ground of religion, on conscience, belief, culture. Those are all constitutional rights that find themselves sitting very easily into the LRA under Section 187. And if an employee is able to found a claim of an automatically unfair dismissal, and in the absence of seeking reinstatement, compensation runs up to 24 months. Now, that is in the ballpark of an employee. Let's move to what it is that an employer would be able to do in an instance where there's unreasonable refusal to consent, because an employer has an obligation to ensure that its work environment is safe. Now, every form of dismissal or potential form of dismissal that I want to discuss would be premised on a requirement that the employer show reasonable accommodation for the employee, and that dismissal is a measure of absolute last resort. Now, there's potentially three forms of termination that an employer could look at, and a lockout I'm going to park without that being a form of termination. 11 years ago, the Labour Appeal Court accepted in the Silicosis judgment that an employer was able to rely upon a concept of incapacity for workplace for an employee's inability to render services in the incapacity realm outside of misconduct on the basis of what is referred to as operational incapacity. What had happened in the Silicosis judgment was that an employee was incarcerated and was not able to render services to his employer, Silicosis, for a period of time because of the incarceration. The bargaining council had found the dismissal on the basis of what it said constituted misconduct for the failure of the employee to render services and failure to comply with the requirements of the conditions of service as a basis of termination. But the Labour Appeal Court eventually found that that form of termination constituted or could be categorized as an operational incapacity termination. So there's a potential that an employee who refuses a vaccine in this instance, which is unreasonable, could fall into that category of an operational incapacity termination. Then moving across immediately to the Section 189 forms of termination of what we classically know as an operational requirements termination, so in the ordinary course. The definition in Section 213 of an operational requirements dismissal to meet for an employer to rely upon in order to meet its requirements based on the economic, technological, structural, or similar needs of an employer certainly would find favor in this context, where an employer can find a dismissal for operational requirements and then have to go through the entire process under 189 to get to a point of a termination is a last resort. Prof. Pina referred to the concept of severance and whether severance would or would not be payable in that instance, and that's something that would need to be considered on the particular circumstances. Another form of termination is potentially insubordination in the form of the categorization of misconduct. And once an employer follows an insubordination route, it will then bear the onus of showing that the instruction that the employee refuses to comply with is both lawful and reasonable, and that insubordination is a basis for dismissal in the first instance. So by and large, those are the categories upon which an employer could look in order to find a place to effect a termination of the contract. The lockdown since March of last year has seen, in my experience, a lot more ingenuity from employees in relation to asserting their rights. So we thought it relevant just to touch on where it is that an employee could potentially look to assert a right against an employer in an instance of either having a vaccine or not having a vaccine. So let's start out with an instance where an employer takes the position that it's not going to impose a vaccine. In that instance, it's not beyond the pale that another employee in the workplace takes the position that I will refuse to work because I can, in terms of the Occupational Health and Safety Act, refuse to render services in a work environment that is not safe. Could such an employee or group of employees in that instance rush off to court, requiring a court order to have the employer put in place a vaccination policy, or at least seriously consider the consideration of the vaccination policy? An application of that sort is not beyond the pale. It's one that can be considered in potentially the High Court or the Labour Court. Then there's the issue of the Human Rights Commission. Over the last number of years, and we've certainly seen it developing since the period of the lockdown, that employees now turn to the Human Rights Commission in relation to asserting or looking to protect their rights in the workplace. And obviously in relation to terminations and the like, there are issues, there are matters that could very easily come before the CCMA. Now, want to round off my presentation with three other very quick topics. One being the liability of the employer, The second is employer agreements with entities that are contracted to administer the vaccine. And thirdly, this just another issue that an employer should seriously consider when it looks at putting in place a vaccination policy. Let's start with the question of liability, because all of this kind of sits very neatly in interlocks with each other. The question of the liability of an employer. The first issue is where there's no vaccine policy and an employee returns to the workplace, and then there's a transmission of COVID in that particular workplace. Our law has developed significantly around areas of vicarious liability. So we're not even going to look at other concepts of the law dealing, but just simply around the areas of vicarious liability. Our courts have certainly pushed the edge on vicarious liability very significantly over the last number of years. One judgment that immediately comes to mind is the Stellian security judgment of the Supreme Court of Appeal in September 2019, where the court found vicarious liability in an instance that was not generally found at our common law. So the potential where an employee does not have a policy in place, there's a transmission, could there potentially be vicarious liability in that instance, or any other form of a delictual claim? Then there's this question with regards to the long-term side effects of a vaccine. So Fura touched on that briefly. And what happens in an instance where an employer does mandate a vaccine, and in time there's a long-term side effect that then develops in relation to a particular employee or categories of employees in time? Now, we'd all be familiar with the silicosis litigation that had come before our courts over the last number of years. The silicosis litigation, and this is well known in the public arena, settled in sums close to 5 billion rand. That's what the silicosis litigation had come to eventually being settled on. So the actual pleaded claims were in excess of 5 billion rand, but this is where the matters had ultimately settled. Now, would an employee who suffers a long-term side effect in that instance have a claim against the employer? Or would that side effect not be a workplace injury, and would the claim then not properly be before the compensation fund? And if that's where a claim is potentially to be found, is an individual not in a safer position to take a vaccine in the workplace, where there may potentially be a side effect in time to come and then have a claim against the compensation fund, as opposed to doing it outside of the work environment? Question. What then is the significance then going to be of the directive which is currently in place, which had come into effect in July 2020 on compensation for workplace acquired COVID-19 in the categories where employers have vaccines in place? So it raises a number of questions in relation to employer liability. I then want to talk about employer agreements with entities that will be contracted to administer the vaccine. Now, whilst human resources practitioners are asked to bring the moon back to the workplace quite often, they certainly are not going to be asked to administer the vaccine to any employee. So that's going to be something that needs to be done by occupational health practitioners. Employers that mandate a vaccine will then have to determine what sort of agreements are put in place with occupational health practitioners in relation to administering the vaccine in their particular workplaces, and what the rights and obligations of those parties are going to be in those circumstances. Questions of liability arise, questions of insurance arise, questions of the general law of contract law dealing, and a whole host of other issues arise. And then finally, on the assumption that there's a mandatory vaccine, an employee then takes time off to go to a determined place by the employer for a jab to be taken. This question will definitely arise. What sort of leave does that employee take in that particular instance? And I'll not give a question. Okay, I'll leave the question open-ended, because that will certainly be one that will be asked 1,000 times as we go through the remainder of 2021. Thank you very much.
Thank you, Imran. Fascinating. More questions than answers have arose. And I think that from the questions that we have got, we've got half an hour for a host of questions, and I'm going to categorize them and pose it to our panel. I think what colleagues and participants are uncertain about is there an obligation to implement a mandatory policy for vaccination? And the answer from our panel is certainly no. You don't have an obligation to do so. The second set of questions are, if we do not have an obligation to implement a mandatory policy, and this is a question for Safura, why would an employer from a health perspective want to take on a responsibility to implement such a policy, given the uncertainty regarding taking vaccines, regarding the issue of herd immunity, and why would it, as an employer, want to contribute to this? And is this not a government initiative that it should regulate whether employees or whether people should take it, and employers should simply exist to create a safe working environment as required in terms of OSHA? And maybe we start off just from there, and then a follow-on is, and while you're on the panel, is to talk about manufacturer liability as a result of the vaccine, and we'll talk to Hugo and Imran about COIDA and that sort of liability. Thank you.
Thank you very much. So to the first question, I think that's 100% correct. There's no obligation on employers at this time, and this is undoubtedly, and I think at a fundamental level, a government responsibility. And I think this conversation really for me is not about what the current obligations are, but what is likely to arise in future, because at the moment there isn't anything requiring mass scale vaccination, but that's very, very likely to change. And I think there is a level of almost self-interest that employers can begin to consider, because this is not just about protecting public health, but it's also about going back to normal, in inverted commas, and resuming our way of life. I don't think that anybody envisions continuing to live in a lockdown type of state for the indefinite future. And so I think this is really about what employers need to consider when going back to normal and having people returning to work, which is something that will happen in the next few years. And I also think it's just important to be mindful that there are likely to be several policies introduced that are going to create conditions that incentivize or otherwise require vaccination. And it's worthwhile to consider preemptively how to integrate those expectations and those policies, particularly if your employees are traveling and the like, or if you work in a high-risk environment like a hospital or other medical healthcare facility, how your organization would want to deal with it. In terms of manufacturer liability, I think it speaks a little bit to the point I mentioned about the unprecedented speed with which these vaccines were developed. And one of the things that was done in that process was a truncation of the trial timelines. Normally one would have lengthier trials so that long-term adverse effects could be observed. Now, obviously some of the people who've received the vaccines have been with those vaccines for quite some time now, and so there's ongoing monitoring to begin to understand what the long-term effects of the vaccine are, including whether or not it's effective, not just whether or not it's safe. There were longer-term safety studies that were done, so I would just sort of add that the vaccines are safe. But you know, in order to incentivize manufacturers to expedite the process, a lot of governments offered them exemptions from liability, and this has been something that's been controversial. It was done in the UK. We don't quite know where manufacturers in South Africa are going to sit, because we don't know the details of that yet, and we don't know what kinds of bilaterals are being negotiated. But it's entirely likely that manufacturers will not be liable. And similarly, where medical professionals are dispensing vaccinations on the belief that they are effective due to rigorous regulatory approval from SAHPRA and manufacturer assurances and warranties, then I don't think there's any liability there. But I think the question, and I suppose I'm going to toss the ball back to the Cliff Decker partners, is whether or not employers can be liable in any shape or form if they're requiring employees to take vaccines. And I think that's a big question for people to consider as they begin to think about what their policies for their organizations should look like.
Thank you, Sufura. And maybe just on that one, to push it to Hugo, to Professor Pienaar, regarding the introduction of a mandatory policy and employer liability. So Imran and Hugo have both touched on that, and we'll give them an opportunity to talk. And just so that the question is succinct, because there's quite a bit of questions that are coming through the chat, which says the following. Step 1, you make it a term and condition of your employment. So you go through the various regulatory steps. Employees say, in your industry, yes, it's a good thing. We want to take the vaccine. You as the employer, as Imran has indicated, ask your occupational health and safety practitioners together with or nurses or another healthcare professional to vaccinate your employees. The only reason they are vaccinating is because of their term and condition of your employment. There are serious ramifications or medical consequences as a result of their vaccination. Where does the claim lie? Maybe start off with Hugo and then Imran. Thank you.
I was hoping that you would start with Imran, but let me give it a shot as best as I can. Well, the interesting point, of course, is that we have already seen in terms of what would the courts expect, etc., in terms of policies. But we've seen that AMCU judgment, and in that case, it was about a decision of the Chief Inspector of Mines not to require employers to prepare a code of practice on COVID-19, etc. And that decision was taken on review to the court, and the court said that decision was unreasonable and it was reviewed and set aside. Now, of course, that's something different from having a compulsory vaccination as opposed to having a policy. But it's interesting that the court's thinking at that stage was clearly about the protection. But of course, protection itself, just to have a policy, does not itself infringe on the rights of individuals. So directly. The other point is, of course, the issue of liability, and we have the provision in the COIDA Act under Section 35 that allows for indemnity again for employers against claims that arises from, and the words they use is occupational injury or the disease resulting into disability or death. So there is that indemnification in terms of COIDA. But of course, generally, and then I'll pass on to Imran, is that, you know, an employer who ever wants to institute a claim like that against the employer to say, well, first of all, you did not have a policy and now I attracted the disease, that difficulty would be to prove that it was in fact attracted on the employer's premises, given the fact that the employee was probably outside of the workplace for a long period of time. The next one, you now impose this policy, employee takes the vaccine and suffers as a result of that, and then the question would arise whether COIDA Section 35 would be sufficient to protect the employer in terms of having an indemnity against litigation. But Imran, please help me.
Imran, you're on. Thank you.
Just unmute Imran.
Prof, there's not too much of help from me this morning, unfortunately. But I want to pick up on the point that you raised in relation to an employee acquiring COVID at the workplace, and the requirement that an employee be able to prove that the COVID was actually transmitted and acquired at the workplace, because that is ultimately the starting point for a claim. In my experience, since July of last year, I've probably had about 5, maybe 6 of those sort of matters come past my desk, where employees assert a right under the directive for workplace acquired COVID-19 and then seek to put in a claim with the compensation fund. The thresholds are actually quite high. In every one of those matters, whilst we submitted the claims on behalf of the employees, I had difficulty in determining the causation, because I couldn't see where the employees were showing the causation. Because how an employee shows that I actually acquired it in a low risk, and fortunately these were all low risk workplaces, is very difficult, and that does become the first point. So on the long-term side effect, I mean, Safura's made the point in relation to the safety of the vaccines. No employer is going to say that there's going to be a vaccine that's going to be administered under a mandatory policy by occupational practitioners that is not safe. So it's going to be a vaccine that's regulated under our law. And my gut sense is that in that instance, where an employer can show that it's complied with its legal obligations, it should have some sort of defense in relation to any claim that arises even down the line. Whether the compensation fund would have a full indemnity is a question that is an open-ended question, where an employee can show that there was a side effect and is able to show that it's a workplace injury. That's open for debate and would really be dependent on particular facts.
Thank you. To our participants who have probably arrived and joined our webinar, hoping to find a clear-cut answer to these vexed questions, sadly, we don't have a crystal ball at this stage. But what is important, from just to summarize what our participants have indicated, is the decision to implement a compulsory vaccination policy is certainly an option available to you, but not obligatory. 2 is whether you do so as an employer depends on what you consider is your contribution as an employer, as part of corporate South Africa, to the concept of ensuring that all South Africans come to a new normal. And it's not just South Africans, but it's the world in general. Because what happens in South Africa doesn't only affect South Africans, because our citizens will travel, and if they're not vaccinated or the like, they impact a host of other entities. And correctly, one of the questions raised, and before I start posing the next set of questions, is are you as participants, or Cliff Decker Hoffmeyer together with Safura, should you not be rather advocating that this be regulated by government, as opposed to creating this obligation on us? And that certainly is a policy decision. In the US, for argument's sake, is the academics have indicated that they are able to, within their current legislative framework, allow employers to actually compulsorily vaccinate employees. What I want to talk about, so the next sort of questions that have come about, and I will go through a round again, is assuming that you say, I'm going to have a compulsory vaccination policy. The question is, must your policy prescribe the particular nature or the particular vaccination, be it in AstraZeneca or anything of that sort? Or can it be any vaccination policy or any vaccination that's approved by the regulatory authority? And I think that's the first thing. The second thing, the second set of questions are, must your policy regulate who pays for the vaccine when you are making it obligatory? Must you as the employer not pay for it? Why must I take it out from my own pocket insofar as you require me to pay for that vaccine? And I think the final question on this is, now we're talking about content of the policy, and the final one is, must my policy have an opt-out clause to say that, like the various case authorities, must we have an opt-out clause that if you refuse to vaccinate, these are the recognized grounds, and if those grounds are sufficient, we will try and find alternative work for you, and if we can't find alternative work, we will then embark on a incapacity process. So maybe we set up those questions and start with, Safura, the one other question was, where did we manage, how did we get to employ you? And I was embarrassed to indicate that Safura is our expert outside of our firm, and although she's a lawyer, she's works for another organization, and we were just honored to have her. There've been lots of questions about your eloquence, so we couldn't take credit for that. Thanks. Safura? Thanks
so much. Yes, I am currently affiliated with a research unit at Adventist, and I should have probably mentioned that, which is we do research around health economics and decision science, which is basically around how to make good decisions. So I suppose it's appropriate that I'm here. So I think the first question is, can you prescribe what type of vaccine somebody should take? I think a lot of the questions actually within that bundle are complicated to answer because the government is currently the sole procurer of vaccines. And as a result, very little is within anybody's control. And I must say that is the global position, is pharmaceutical companies have opted to negotiate with governments, not with private buyers, with the exception of Gavi, the Vaccine Alliance. And so it's very difficult to envision a situation where an individual, even an employer, would be able to exercise a level of control or preference for a particular vaccine. However, there may very well, it is very likely that we're going to have multiple different vaccines being rolled out in South Africa. Already we're seeing that AstraZeneca, we have a limited number of doses. The AU has procured some doses of Pfizer for healthcare workers, and so already there's going to be people receiving different types of doses. Professor Barry Shube mentioned yesterday that there are 292 different candidates in development, and a lot of those are going to be getting results coming out over the next few months, and many of them are slightly more feasible in South Africa. For example, they don't require special refrigeration, or maybe there are only one dose, and so it's very likely that there's going to be a preference for certain types of vaccines in South Africa, and that is really an unknown. I think at a minimum, when thinking about this, you should try and prescribe that the vaccine at least be above 70% effective, and that's because anything lower than that, it's not going to achieve herd immunity, and so it's kind of not going to achieve the purpose of mass vaccination. It will protect an individual to some extent, but not achieve the broader goal. And I think that is the threshold that SAHPRA has adopted in terms of approving a vaccine. So I think requiring that the vaccine be a SAHPRA approved one is probably a good starting point. In terms of who pays, I will say that the current position is that if you have medical aid, the COVID-19 vaccine is covered as a prescribed minimum benefit, and anybody else who procures it through the public sector, the cost will be covered by government. So at the moment, that's our position, but for people who fall in between, where they don't want to use the public service and are self-financing their interactions with private, that would be a good question to ask. And I think the employment lawyers can answer that one. Finally, I won't go into the nuance of the opt-out clauses, because I think it's been beautifully outlined by Imran and Professor Pina, but I will say that there's no one-size-fits-all. There's going to have to be an allowance for people who can't get the vaccine at a minimum, and that's people who, for medical reasons, cannot receive it. But I think there's been almost no situation in which a blanket compulsory policy would withstand scrutiny. I'm sorry, I wrote down only one word here, so I can't remember the fourth question. So I'll just leave it at that, unfortunately. But yeah, if you remember, then I can try. If you remind me, I can try and answer that one. But I hope that starts us off. I'll hand over to my co-panelists.
Imran, you want to go?
Thank you, Prof. It's clear that Safura is more than a lawyer. It seems that she's a doctor with a handwriting. That was I just could not but help say that, Safura. I think you very eloquently covered most of the issues that were raised. I'll deal with the issue of the opt-out, and before getting to an opt-out, I think what would be very beneficial for any employer is to set out exceptions that can be relied upon by an employee to not to consent to a vaccine. So let's use religion or other medical conditions as an example. Religion is complicated, but assume that there was an easy answer for a particular person with a religious belief that says, I cannot take for religious beliefs the vaccine. If that employee is able to establish that would be a justifiable reason why that employee can be excluded from the policy. An employee who has comorbidities and for whatever medical reason is precluded from taking a vaccine, well, that would be a justifiable reason not to take the vaccine. So it would be very useful for an employer to have a list of what would be justifiable exclusions, and give an employee an opportunity to tick on that and then provide the explanation, and then to get into a discussion with an employee on their particular circumstance. Where you get to a point, sorry, Prof, do you want to come in on that point, and then we can perhaps
No, I really like the point that you've raised. I think it's such a good point, because it's also about giving employees an informed consent and all of that. And as Imran correctly stated, we must be so sensitive about that. I would add one caveat to that, and I think you were potentially going to get to that, but you would have that invitation, but each case to be decided on its own merits. Because if you have a workforce of 100 and all of a sudden 50 says, well, there's a cultural or religious belief, then one must maybe revisit whether you would have a blanket exclusion. We've seen in the employment environment during strikes in particular that employees often, when they take Shambox to a picketing line, they say, well, it's a cultural right. And of course, we've dealt with that where we've said, but it's a strike or a picketing is not a cultural event. So one must just always remember that depending on the response, one may want to consider in each case in its own merit. But I interrupted you, Imran, my apologies.
No. Indeed, Prof, I mean, those are valid points in relation to the particular circumstances. And then I guess the natural consequence from the initial question gets us back to the point of, well, what then happens with that particular employee? Is the employment then to be terminated? And I guess, well, perhaps not, depending on the circumstances. It goes to the initial point on, can that employee be accommodated in their particular position on another mechanism of work from home or something else, or is there another position that the employee can take? So dismissal is certainly not going to be the first resort. It must be the last resort in relation to this instance.
Good. Thanks, Imran, and thanks to all our participants. We coming to the end of what could only be described as a fascinating topic. We have answered many questions that have come through the chat. You should, or you will be receiving our information guide, which will encapsulate a host of these things. We will potentially have another series of these webinars, or another webinar on the vaccination, and hopefully Safura will, and her organization, Priceless South Africa, where she's a senior researcher at the School of Public Health at Wits University, will honor us with her presence and talk about this as as government policy develops. I think the parting point is the following. Read the 1945 book by Albert Camus, and sorry, I'm a French philosopher, so we're trying to advocate that book. It gives you a good insight on what we are going to experience. Two is, you need to decide as an employer, are you going to be the first out of the starting blocks, or are you going to wait for government to give us some sort of direction? Three, and most importantly, if you are uncertain, please contact one of your representatives in our employment department. Their pictures and their contact details are on the information guideline that was provided to each of you. Thank you for the host of questions, and those that we did not get to, we apologize. The recording of this will be made available on various social media platforms by our marketing department, where you will be able to listen to them and engage with the material. This year is an educational process for all participants. Thank you all, and good luck. Thank you.